Thanks for staying with us. Well, we understand that the president will sign the appropriation bill today. At least that one will be signed. But one that's been unsigned is the one we want to talk about now. And the issues raised, how significant are they? What if the president had signed it? Well, Lanre Arugundade joins us this morning. He's Executive Director, International Press Center, IPC, Nigeria, and a member group of CSOs on sustainable electoral reforms. Thanks for joining us this morning.
Good morning. Thank you very much.
Let me just go straight to that same question. What if the president had signed this bill? How significant are these drafting and cross-referencing errors and gaps?
Well, they could still have been corrected. The president could have signed the bill like he did to the PIB bill. And after signing, after it became law, they then requested for some amendments. That would have been the route that we would have preferred, because we're talking about the law that will govern the elections in 2023. And essentially, we are engaged in a race against time, because we want a situation where this law comes into effect so that it can be used, not just for the 2023 elections, actually, but for the off-cycle elections, Ekiti governorship election, Osun governorship election, and the FCT elections. So the whole idea is that the new innovations in this electoral bill 2021 could actually be tested through those elections before we go to the bigger one, which, of course, would be of greater concern to almost everybody in Nigeria. For example, the provision that empowers INEC to use electronic means to transmit results, to avoid all these problems of collision, and it gives a background of insecurity. These are very, very key provisions. You have Section 3 of this bill, for example, that also says that money should be released to INEC at least 1 year before the elections. There's also Section 65 or so of this bill that talks about the fact that INEC could take a decision where results are declared under duress, or where they believe that there's been a clear violation of the law. So this electoral bill, unlike previous ones, actually guarantees the independence of INEC. That is why, for example, when it comes to electronic transmission of results, it didn't say that it should be subject to any other authority but that of INEC. So looking at all those provisions, we would have preferred a situation where the president will have signed the bill, signed it so that it becomes law, and then we seek these amendments.
Okay.
Now,
just a quick one before we continue. So those issues are there. And then one of the questions that came to my mind is, given the process of lawmaking, and this electoral bill, it's been on for like how many terms now?
Yes.
And to also still raise these issues, and then this particular version of the Electoral Act Amendment Bill has gone through the normal routine: first reading, second reading, public hearing before clause by clause considerations and all of that. And yet you're still able to identify 11 of these errors. How significant are these particular things that you do?
Well, they are significant to the extent that it may be a reason for the president not to assent to the bill. Some reasons have already been adduced, and the National Assembly have said we would meet. We may drop the whole issue of direct primaries, because those are the contentious sections.
I know
you are coming to those errors.
The reason I'm asking is,
because in August 2018...
Sorry, my apologies,
yes.
Mr. Agundo. The reason I'm asking is, how did we miss those ones in the process?
I think it talks about the gaps in capacity when it comes to lawmaking in Nigeria. And I think going forward, these are the areas that we need to address. Because like you said, really, we have in National Assembly, we have committees. These committees also work with experts in different areas. And one would have thought that internally they will have seen some of these errors and get them corrected ab initio. it shouldn't be the responsibility of we in the civil society to identify these errors. So perhaps there are capacity gaps, and I feel that we need to look at legislature, because my understanding of the legislature, from my experience at least with British democracy, where they run the parliamentary system, and American system, is that senators or members of House of Representatives, they have a whole retinue of experts that work with them. And I'm sure all of us have seen public hearings, maybe it's an investigation and so on. Okay. The kind of questions that senators ask in those places, they are even tougher than questions that judges would ask. So for me, I think it shows that we have problem of capacity, and our legislatures really need to do their work, very well.
Okay.
So for me, these errors ordinarily should not be there. But why we are coming out to draw their attention to this now is that we do not want it to be a basis for the president not to sign the bill after they might make necessary amendments. Because in 2018, August 2018 precisely, the president did not assent to the electoral bill then, because he said there were cross-referencing errors, there were all grammatical errors and so on. So our fear really, and that's why we're saying now that the president has sent the bill back and you are looking at it, before you retransmit it to the president, ensure that these errors are corrected. Okay. And some of them are quite fundamental.
So let's look at some of them. Which ones would you consider quite significant that need to be given due attention? Okay,
so you look at in the way we have arranged it, we look at some of the subheads, and you look at let me mention one of the subheads. So you look at 14.2, for example, where it talks about amendment to election petition, and it was talking about the fact that there must be compliance with Section 134 of the Electoral Act. Meanwhile, Section 134 has nothing to do with election, petitions or amendment or anything like that. The section that ought to have been put there is Section 2885 of the Constitution.
Subsection 5.
Subsection 5 of the Constitution. So if you allow it to go like this, it could be a basis for litigation in future, because you'll be using, a law that has no bearing to reality. And somebody could say that, look, on the basis of this, we have problems. Then you have some sections where you have repetitions. So if you look at paragraphs 4, 5, 6, 7, and 8, for example, paragraphs 4, 5, all of them are essentially repeating, the same things. In some areas, you have, duplication. You have, errors, in references. When you have all these laws, you also have subtitles. So what we did was to just painstakingly identify all those ones, and we do hope that there are no other ones, so that the National Assembly could be well guided in reconsidering this particular bill that, as I've stressed, is very, very important and could really help us to have much more credible elections in 2023.
I see that part of the amendments that you are recommending includes 24 sub 4,
yes,
which talks about conduct and postponement of election in an emergency. That's quite significant, because we've had a case in this country where there was a postponement of election. How significant it is? Talk us through that one.
Well, that is also very, very important, because we recognize the fact that we're going through a whole lot of conflicts. And we also recognize that politicians want to win elections at all costs. And so you might have a situation where crises are deliberately, concocted just to prevent the electoral process from proceeding accordingly. And so we're also saying that, look, we need to look at this section to ensure that in case of emergency, we do not have, an undue, delay. There must be a reasonable time limit within which that election, should, be conducted. Because our elections come with all kinds of things. It comes with all kinds of litigations and the rest of them. And that is why we're actually concerned about the issue of time, really. And for us, what is important, because the president returned this to the National Assembly. It took a whole month for the president to take a decision. That in itself shouldn't have been the case. But we consider that the president has the right to also make consultations, because he is the president of the country, and he should be concerned that whatever electoral law will come out should be the one that is acceptable. But that period was too long. But now it's back. And what we want the National Assembly to do is not to exceed 1 month in getting it back to the president for his assent. so that this can then be the operating law for the elections that will come. You know, the ECOWAS Protocol on Democracy and Good Governance recognizes the importance of timeline when it comes to electoral law. And so it says that electoral law must come into operation at least 6 months before the elections. The same thing, the African Charter on Democracy and Good Governance. So we're looking at these frameworks, and Nigeria is a signatory to these frameworks that I've mentioned to ensure that we do not put, unnecessary cogs in the wheel of our electoral progress.
Well, I would suggest that everyone watching this program right now should, I don't know, this document, I'm sure you have it available.
Yes,
in the media
we'll try
space.
and make it widely
important
available.
so that people will understand
really
what the issues are. But do you think this law itself, this bill, as has been proposed, does it in any way significantly take on the issue of electoral violence?
Well, it's that in itself, I think that is very difficult, really. And don't forget that one of the things we've been advocating for, really, is that we should have a separate mechanism for dealing with electoral, violence, because you want the INEC to be the one to, prosecute electoral offenders. INEC does not have its own police to even arrest, talk less of prosecuting, and that is why there has been a case for a kind of, special commission that deals with issues of electoral, violence.
Okay.
Just like you have EFCC, for example, fighting aspects of our corruption. And because of that, EFCC is empowered, it makes use of the police and all that. You would need a separate commission to deal with that because of electoral violence.
So essentially you are asking for
we've talked about electoral offences tribunal and so on, because a lot of responsibility, and the chairman of INEC did mention this in his chat with media executives in Lagos, recently, where he said that a lot of burden is put on INEC. For example, voter education, for example.
Voter education.
Exactly. And we have been saying, look, why don't
question.
you just take this one and make it the mandate, the sole mandate of National Orientation Agency?
Well, that's a big question there.
It's a big question,
but, the voter education part is what raises this next question that I want to ask. And that is voter apathy that seems to be dwindling on a gradually. Is there any way that you think that this law also, addresses that?
It's difficult for the electoral law to address the issue of voter apathy. What the electoral law can do is to enhance credibility of the electoral process. So we're hopeful, for example, that if people realize that their votes would count, that the results that will come out would not have been manipulated at the collation centers, that violence will not matter. And that's why the good thing about this law, for example, it talks about the fact that where you have elections at polling units, there are, electronic. Don't forget the controversy in the last elections, whether there is a server or there is no server and so on. It will eliminate this. So what it can do actually is to enhance confidence in the electoral process. And we then hope that that in itself would encourage people, because the reasons for voter apathy are many. It's also a reflection of lack of confidence in the electoral process. The fact that we do not have, democratic accountability. People make promises, they do not fulfill them. A general sense that, the political class has failed citizens. So people don't really see the reason to vote. And that is, a different ball game, entirely. But for those that would vote, no matter the population, we want a situation whereby the electoral law will ensure that the votes count, and that the whole process itself, it's credible and adequately guarantees the independence of the electoral management body, which is INEC. Okay.
Malcolm?
Well, I was listening to Mr. Arogunade, and he was saying that, these amendments, these errors which they have noticed should be fixed before it is sent back to the president. Now, this is assuming that it is sent back to the president, right? Why do you think that this bill should be worked on and sent back to the president?
It should be worked on. As I've stated, it's an improvement on the Electoral Act 2010 because of a number of reasons. So this is a major improvement. And because of that, a lot of energy, a lot of time, a lot of resources have been put into having this particular bill. And it would be too bad if, despite all those investments in terms of time, in terms of resources, we just send it away, and then we are back to square one. And we then may have an election in 2023, and even before it,
Sorry to interrupt you, Mr. Arogunade. The emphasis in my question, if you can hear me, was why it should be sent back to the president.
Well, it should be sent back to the president to ensure that the law comes into effect in good time before the off-cycle elections of Ekiti and Osun and the other ones. Maybe what you are trying to say is that why can't they just veto the president and pass it, really? It was one of the demands we made in our press statement of December 2, that the way things are, they could actually either veto the president, but you already read about what it will require to do this veto. Two-thirds majority, and of course a lot of politics will come into this. Already there is a lot of talk around the question of direct primaries. So we're saying that, look, if those are the contentious issues, drop them, because there are other provisions in this bill that would enhance the credibility of our electoral process. So they should really, because we need to look at our own political environment, the kind of controversy that it will generate. And we may end up not having a law that would properly guide the next elections. So the way we look at it is that the best option before us now is for them to look at those issues raised by the president, and then also look at the issues raised by the civil society organizations in terms of those errors that we've identified, and then send the bill back to the president within a month.
Well, some of the reasons why the CSOs, which painstakingly did this work, is because of what has happened in the past. The president has rejected Electoral Act Amendment Bill based on grammatical errors and clerical errors. And that's one of the reasons why I imagine that the CSOs have done this much work looking through for those kinds of errors. Now, some people have said, based on what they have seen, the president is reported to have rejected the Electoral Act Amendment Bill a record 5 times. Based on what they have seen and the president's antecedents in rejecting these Electoral Act Amendment bills, they think that perhaps there is no good faith shown in this particular stance by the presidency of wanting to sign the Electoral Act Amendment Bill into law. Why are you confident that, having done this much work, if it is sent back to the president, it will be signed this time around?
Well, so what we're trying to do this time around is for us to ensure that the president does not have any excuse not to sign, this bill. That is why, we're taking this, route to ensure that the proper thing is done. So you already said it. In 2018, it was rejected because of these cross-referencing errors. We've identified them. We've drawn the attention of the National Assembly, and we have said, do the needful. The president, in their response, and some of the spokespersons for the president, talked about the fact that, the direct primaries, and there are other people who also feel that political parties should have the right. There is, of course, some merit in direct primaries, but for us, that is also not as significant as other provisions. So we are also advising the National Assembly, leave that one aside. So the whole idea really is, let us see what would then be the reason for the president not to assent to this particular bill, given the provisions. And the same president has actually said that he wants to leave a legacy of credible elections. You can't leave that legacy if you do not have an enabling law that allows you to do, the needful. So all we're saying is that at the level of Mr. President, you have to walk the talk. And at the level of the National Assembly, do your duty properly so that people will not say, oh, well, you can't blame the president. How can you, be making all these kind of, errors? That's why the other time I said, actually, some of these errors are embarrassing. Because it happened in 2018. It ought not to have happened. But
maybe we should allow the National Assembly to take this on now that, of course, these things have been pointed out. Because I saw one there, die instead of dies, or dies, I don't know. It's a whole thing. Well, Larry Arogunade, Executive Director, International Press Center, IPC Nigeria, and member group of CSOs on sustainable electoral reforms. Thank you so much for your time this morning.
Thank you very much for your time, for your interest in this important topic.
Oh, we certainly are.